Mr. Knox.
My Lords, I'd summarised the first point I want to make before lunch. The second point I make is this. Insofar as you take into account what I call the new issues, that is to say, the deportation order being only against the Second Appellant and the subsequent passage of time since the Court of Appeal's judgment, I say on the first point that there is no illegality in the fact that the son is being detained together with his mother because a valid deportation order has been made against the mother. He has been entrusted to her care, and neither of them wants to be separated from each other, and that is absolutely plain, and there's been no application for them to be separated from each other.
But he's applied for habeas corpus.
Yes.
And the habeas corpus writ requires a return stating the legal basis of his detention.
Yes. And one would say on the face of it, well, you need a deportation order for that, my Lord. I anticipate that's the point that's made against me. To which I say, well, yes, that would be the case in the normal case, but when you're dealing with a minor, and it is clear and undisputed that the minor is entrusted to the care of the mother, then in my submission, that's a sufficient return, unless then it is said, well, I don't want to be with my mother, or I want to be treated separately from her, or in a different way, and there's someone else who can look after me. There is a vacuum, I accept, and that's part of the problem in this case. Where is he to go? But, my Lord, that's what we say, and I understand your Lordship's point. You said there must be a deportation order against him particularly in order to detain him, to which we say, well, no, on the facts of this case, that doesn't follow, because he is in the care of his mother, and he has not, through his mother, made any separate application.
Is it right to say that the position you've taken up till now is that the order against the parent was to be taken as an order against the child?
Yes, it's to be taken to be, it is in respect of, I mean, that's another way we put it. In other words, one order will do for both, unless, of course, the point is taken that it won't, but we say it never was.
But if that's right, it's curious that the child's not named in the order made against him.
Well, I accept he's not named. But the policy, my Lord, I'll have to come to this, the policy of the Minister is that he issues these orders which are to cover both the parent and the child without, as I understand, necessarily naming the child. But, my Lord, it's a very unattractive answer, but I suppose it's not a bad answer, if there can be such a thing. But it is rather technical, all this. I mean, everyone knows what's been going on. The point has always been there to be taken from day one, and it just wasn't. And it's not suggested that if the child had been named, anything different would have happened.
The point has been taken now.
It's been taken now, I agree. And, well, my Lord, I accept.
The meaning of Section 16, doesn't it?
It does.
Section 16 says any person in respect of whom a deportation order has been made.
Yes. Well, my Lord, you'll have seen from our case how we construe that. We say in respect of can cover, on the facts of this case, the son, because it's been made against the mother and she has care of him. And
this is liberty of the subject.
My Lord, I accept that.
And you're seeking a very broad interpretation.
On the facts of this case, I would say not a broad interpretation. I would say one which is consistent, in fact, with the policy which has been adopted, and it doesn't prevent, in my submission, the son saying, well, you haven't, from day one, you didn't serve a deportation order on me, or indeed the mother on behalf of the son. And that's what it comes to. Well, I accept your Lordship's point. It could be said, technically, we're wrong, but I say, in reality, where does that actually leave things? Bearing in mind the nature of the relationship between the mother and the son. They both got legal representation, albeit the same, and it's never been, the point wasn't taken until, properly taken, until the application for permission to appeal.
Yeah, well,
to the Privy Council.
I mean, that's this train of thought that led me to ask what would happen if this child were, as it were, left outside the front door of the institution. And
yeah.
And as you properly pointed out, that's an issue that nobody has actually inquired into in these proceedings.
But, my Lords, I'll develop my point specifically in relation to the son and interests of the child later. But that's our basic position. We say no illegality for the reasons I've just outlined and in our case. As far as the further passage of time is concerned, since the Court of Appeal's decision, which is July 2021 until today, we say that shouldn't be taken into account as part of any relevant delay because that has been caused by, and only by, the underlying constitutional motion, which we say is a weak application, or at least even if it's not a weak application, there's no criticism that can be levelled at the state for the fact it has taken so long. And we say 14 months, of course, is a long time. We accept that. On the other hand, when you look at the Hardiel Singh cases, it's not necessarily 14 months, it's not necessarily regarded as an exceptionally long period of time. But, my lords, if you're against me on what I might call my new points, I submit these are matters that should be remitted to the first instance judge to decide as soon as possible in the light of all the evidence.
Insofar as you've sought to cure any problem about the first appellant's detention by service of the new deportation order, there's the Torres point is being raised.
Yes.
I don't know if you've even given any thought to whether you accept the soundness of the Torres judgment or if it's something you would want to contest.
Well, we have given it thought, and you can imagine what we think about it. We just say it's simply wrong. In particular, but I'll deal with this later, in particular on the facts of this case, because the background to Mrs. Justice Quinlan Williams's order was that there was already a deportation order against the mother. Therefore, you cannot read the order she made as preventing the making of an equivalent deportation order against the son, as long as no further steps were taken on either order. So we say that there's, and we'd also say in any event, it's the decision in Torres is wrong. The fundamental point is the order, Mrs. Justice Quinlan Williams' order, prevents there being steps taken to remove. But the mere service of the deportation order of itself with detention is exactly the opposite of removing, not moving anyone anywhere. And it does not say to remove does not mean you are prevented from taking steps to detain. And if that had been intended, it would have said so. So that's what we say on the second point. And, my lord, you are right. The purpose is obviously fairly obvious. The purpose of the second order was, in the light of the point now being taken against us, that we needed one, then we say, well, here is one. Now, I fully accept you can't decide the legality of that now, but that would be a matter to be decided on a remission or on a further action.
Are you going to come back to those orders, or does that complete your submission on them?
No. That's just a summary of what I'm saying. But I will
elaborate. Last point.
Well, I'd like to take you to the order itself, but I'll do that as I'm going through the chronology. Yeah. My lords, I submit it is terribly important to look at, to have in mind the actual facts as they gradually occurred up to the Court of Appeal's judgment to see whether the Court of Appeal went wrong. And we say, if I may take you to page 469 of the bundle. There's the chronology there. And what I'd like to do is just take you through the chronology and then to one or two documents which are referred to in the chronology and one or two documents which aren't referred to in the chronology but in the same chronological sequence. And it's at page 469, I think I'm right in saying, of the bundle. And I'll pick it up. You'll see there is a first attempt to come in on the 17th of November. They're sent back, but then the boat returns on the 22nd of November. Sorry, they're turned away on the 22nd, but the boat returns on the 24th. And then on the 2nd of December, Madam Justice Charles restrains the respondent from taking any steps to remove the appellants during the quarantine period. My lord, the reference for that is at page 24, if you want to see that order. And the quarantine period, of course, is referable to the COVID regulations point. Perhaps I should take you to page 24 of the bundle, so you can see the order. Sorry, 22, I think, 22 of the bundle.
So that's any steps during the period
on quarantine.
The quarantine.
And the quarantine period finished on the 15th of December 2012. And
so it ended on?
15th of December 2012. The reference for that is at page 47, para 9. 2020, sorry. Page 47, paragraph 9, that's where the quarantine period ends. Now, on going back, I think, to the chronology, on the 15th of December, page 470, you'll see it says quarantine period expires. On the same day, the appellants granted interim relief by Mr. Justice Rahim, restraining the state from removing them from the jurisdiction pending the outcome of another case, an appeal. And I should take you to that order. It's at page 26. And this again is in the constitutional motion, which by now has been issued. 25 it begins, and then 26. This is all, obviously, being done very quickly because it appears the application and the order were made on the same day. And you'll see the order, the respondent is otherwise restrained from taking any steps to remove or from removing the applicants from the jurisdiction. Now, my lord, what we say there is that cannot conceivably have been construed as, by anyone, as an order preventing detention, or an order preventing a deportation order, which does no more than state the fact of the order and have the consequence of detention. Because this, as I mentioned a moment ago, was all done on the same day, and it can't be suggested this was intended to prevent detention or anything like that. My lords, on this same day, 15th of December, going back to the chronology, this is not in the chronology, but I just want you to note, if I may, that the mother was interviewed by immigration officers and was found to have entered illegally. And the reference for that is page 88, paragraph 9. And on the same day, a detention order was issued by the chief immigration officer against the mother. And you get that from page 47, paragraph 9. My lord, I think that was not pursuant to section 16, but pursuant to other powers in the Act. But paragraph 9, I think, of page 47 explains how that came about. Sorry? Paragraph 10, I'm told by Mr. Strang, so I apologise for that. Paragraph 10. I'll read it out. As a result of these findings, Mrs. Hernandez was issued with reasons for arrest and detention form informing her of the reasons for her detention. Further, on the 15th of December 2020, a detention order for the relevant station was issued. And then the minor Jesus remains in the care of his mother during the period of detention. So that's what happens on the 15th. Then going back to the chronology, on the 22nd of December 2020, the Court of Appeal, in the other action, P326, allows the appeal, and that you can find that order at page 29. And as Mr. Ramdeen accepted, that brought to an end Mr. Justice Rahim's order, because Mr. Justice Rahim's order was expressed to continue only up until the determination of this appeal. And that's at pages 29 and 30. And, my lord, just one point to note in this, page 30, and this is the Leon case, the Valeria de Los Angeles Leon case. Page 29, you get the title. Page 30, you'll see that the appeal is allowed. An injunction is granted that the respondent, through its servants' wages, is restrained from taking any steps from removing the claimant child from the jurisdiction. So it's specifically directed at the child. And the point being taken in this action in clear terms is you can't remove the child.
I'm sorry, you just went a little bit fast for me. We're on page
30.
30. And this is an order made in the present proceedings.
But by the Court of Appeal in different proceedings.
Oh, right.
And this was the order pending which Mr. Justice Rahim's order was expressed to last. So
I see. Yes, thank you. Yeah.
So there are 2 points I make. One is, at this point, the Court of Appeal having made its order, Mr. Justice Rahim's order comes to an end, and there is therefore nothing to stop a deportation order from this point on. Secondly, we say the point being made here is that this is a child who is the subject of the order, but on different facts, because this is not a case where there was a mother and child basically operating in tandem. This was a case where there was a child on his own. One then moves along to 12th of January 2021, which again you can see in the chronology, but the relevant page, if I may, is page 35, where the attorneys on behalf of the appellants write a pre-action letter, and in summary they explain how they've come to enter. They raise various legal arguments, but on page 37 you'll see they say you can only detain us under section 16 of the Act, and so on and so forth. And then they go on to say what has happened so far, namely they brought a constitutional motion. And they say at the foot of the page, page 37, as an asylum seeker registered with the UNHCR, my client is entitled to protection. So they raise the asylum point at the foot of page 37. So they say you can't detain us, and so forth.
Can you help us in relation to the implementation of the UN?
Of the UNCHR?
Yeah.
Well, I don't think I can. When you say as to the implementation, you mean in Trinidad?
Yes.
I'm not sure. I think it... Sorry? Well, I don't know if it's formally been implemented at all. I mean, and there's no statute which has brought it into effect. It hasn't been incorporated into domestic law. It is recognised, obviously, generally outside Trinidad, that there is something you can be registered with. I think that's what it means. It doesn't mean registered with the UNHCR organisation which operates in Trinidad.
Thank you.
And others outside. So that's the complaint. Now, on that same day...
I'm sorry to interrupt you. Yes, you tell us in your case that Trinidad has never incorporated the convention into domestic law or treated it as binding in domestic law. Does it have a dual system of international law?
Oh, certainly, my lord, yes. I remember, I say that rather quickly, but from my experience in previous cases, that is sort of one of the points that gave rise to quite a lot of contention in the late 1990s. Yeah. But it is a dualist system. So we say these international conventions are just that, but they don't have direct effect, or they haven't been brought into effect for domestic law purposes. The only statute which, so far as I can make out, which does operate, or rather tell one how asylum seekers should be treated, although they don't put it in as many words, is the Immigration Act and the Immigration Regulations, which does say something about the problem of how to treat people who want to come into the country. Then, in any event, the complaint is made, and on the same day as the complaint is made, the deportation order is actually issued. And if you go to page 71, you can see the deportation order itself, and it's issued on the 12th, which is the date 2/3 of the way down the page.
Sorry, page?
71.
Thank you.
Issued on the 12th, and it is, I think, served or served on and signed by the mother on the 14th. My lords, I just want to draw your attention to the particular sections which are relied on. And this follows the standard form, and you'll see it says about, after naming the relevant sections, halfway down the page it says, I hereby order you to be detained and to be deported to Venezuela, and I further order you to remain out of Trinidad and Tobago while this order is in force. It's a standard form. And she acknowledges service. Now, on the 14th. Now, on the same day, the 14th, the chief immigration officer writes to, I think I'm right in saying, the appellant's attorneys. You'll see at page 45. Informing them that the deportation order has now been served. say, served, informing them of the making of the order. And then at the foot of 45, going on to 47, they set out the reasons. The Minister sets out the various reasons. Essentially, you've entered illegally in breach of the immigration rules, and also, my lords, important to note, the COVID regulations as well. I mean, this is a serious breach. Not even Trinidadians could get in at this point. You'll see paragraph 8. It says the quarantine period came to an end on the 13th. I think it should be 15th of December. It doesn't matter very much. Paragraph 9, after an interview was conducted on 15th December by immigration officers with an interpreter, your clients were determined to have entered the country illegally, and nonetheless entry was not in accordance with the Act. And then, as a result of these findings, issued with reasons for arrest and so forth. And then you'll note at the last sentence of para 10, the minor Jesus remains in the care of his mother. And then on the 12th, the order was made, and then, as a result of the circumstances of the above, the division maintains that Ms. Hernandez is lawfully detained, and thus the division will not undertake to offer her release on an order of supervision. My lords, the statute provides for that. Or otherwise, my lords, I emphasise this at this time. And then it goes on to talk about the child. The immigration policy, though unwritten, is such that in accordance with the United Nations Convention on the Rights of the Child, the division operates as far as reasonable to avoid separation of parents and children. And then, my lords, can I just ask you to read the next paragraph, and indeed the paragraph after that, on which we do place some reliance.
Which page?
Page 49.
Thank you.
The paragraph beginning, to date, no adult parent. So first of all, my lords, you'll see essentially 2 points. We say, well, we don't know who the child should go to. Let us know. And we're saying this to the attorneys. And we don't get any response to that ever. They don't say, send them off to X. You'll also see the final paragraph saying we're seeking the advice of the Children's Authority for about alternative suitable accommodation. Now, my lords, there's no further evidence about any of that, I have to confess. But again, my lords, the point isn't taken up at all by the appellants, saying, well, you know, what have you
find out? I'm sorry for interrupting. If you find out about the father in any event, if you look at page 302, paragraph 30, there's information about the father. There's information about the father at page 127 and 129, letter B.
My lords, I missed the page. It's 127.
127 is one of them. 129, letter B is another. 302, paragraph 30 is another. 302.30 from recollection.
Yes.
Is your own document. And
Can I just deal with those references, my lord? The first at 127 is the appellant's grounds, part of the appellant's grounds for permission to appeal to the Privy Council, served in November 2021, so a long time after this. But we weren't told, so we say this, I mean, it wasn't as if we were told all this in January at all. Indeed, we weren't. So this is later, much later material, which was not actually put in evidence as such, and this is just grounds, of which there was simply no evidence, as far as I can make out, at all, before the courts below. So this is assertion.
I just can't quite follow the one at page 302, paragraph 30.
My lord, yes, if I can just have a moment to dig that up.
Made an application on behalf of the father claimed in those proceedings, but they received no response to a request.
Yes.
It may be different proceedings for all I know, and
my lord,
maybe these proceedings.
I think, my lords, this I think is a reference This is an affidavit which is made in the constitutional motion. And you can see it's dated 30th of November 2020. So, in other words, this precedes the 12th of January 2021 letter. And, my lord, we think it may be a different child, Zaid Jesus Marcano Contreras. So this would appear to be about a different child.
Yep. Okay.
My lord, I don't know if those are the only two references, and you may have mentioned another one.
Well, there's 129 letter B.
125, my lord.
29. 129 letter B.
Oh, my lord, again, it's the same point. This is all part of the application in November 2021. So, our position is that in January 2021 and thereafter until November 2021...
the aunt.
Sorry?
The aunt who also lives in Trinidad.
My lord, forgive me, the sound went a bit...
I'm sorry.
Sorry, quiet.
If I was trying to find a placement for this child with a member of the family,
Yes.
then a paternal or maternal aunt would be presumably something to investigate.
Yes.
And and also it might be something to investigate if one was unlawfully detaining a child as to whether the father was in fact a suitable placement for that child. And
yes. Well, my lord,
I was just wondering what action, if any, was taken
my lord,
to deal with those points.
my lord, I'm not able to say what action was taken, and there's simply no evidence of it. I think all I can say at the moment is, well, we specifically asked the attorneys for the appellants, what do you want to have done? And we got no reply at the time. Now, we also said we were seeking guidance of the Children's Authority Act, to Children's Authority, but, my lord, there's no evidence as to what happened on that. All I can say is that that doesn't seem to have been pressed by the appellants either. It's an unsatisfactory position, my lord. I can't deny as far as the child is concerned, but the state is under great pressure. I mean, you'll have seen some of the, and one of the great problems it faces, I will come to this later, is the amount of minors being brought in and we say, being used effectively as Trojan horses for people to get into Trinidad. And there's also a terrific problem with trafficking in young children. So you can't just sort of... that doesn't answer the point about children.
I saw that in the papers, and obviously it raised very considerable concerns on my behalf. Because if there was any suggestion this child was being trafficked, real concerns about whether this child was being trafficked, as opposed to being the genuine son of the mother and the genuine son of the father, then I would be very interested in that.
My lord,
but to raise that as a spectacle, as a matter of interest and concern is one thing, but putting some flesh on the bones is another. And I was wondering whether or not you are genuinely saying that there's a real risk that this child has been trafficked.
My lord, we're not saying that, but we are saying there are great difficulties in simply handing children over to unknown people. If I know you are, as it were, Mr. John Smith of such and such an address, and I can check your details, that's one thing. But if I have no idea who you are, you just say, hand him over to me, and I just can't check, then it's another matter.
But you have the child's birth certificate?
I'm not sure, but we have the child's birth certificate.
That's my understanding. I could be wrong.
No, my lord, no. We don't. There's no passport, no visa. In a sense, we just had to take it all on trust, as I understand it. So it's not an easy position for the authorities in Trinidad at all.
And do we know if a father is residing lawfully in Trinidad or is there clandestinely?
Well, first of all, we don't know if the person who says he's... Yeah. We don't know if the person who is said to be the father is the father. Yeah. I'm told by Mr. Hussein, you heard, his name is different, yeah. And I'm not sure we even know if he's in Trinidad.
The very first port of call usually is to actually interview the child and to find out from the child what the background is.
Well, my lord, I don't think there's any evidence the child was was interviewed. Just the mother was interviewed.
Yeah, I know. But if you had concerns about whether a child was trafficked, it might be a simple precaution to take, just to make some inquiries of the child.
My lord, I can't answer that question myself. These are points which haven't really been taken below as part of the problem, and I'm, in a sense, having to do my best without material to answer your questions.
Yes.
Yep. My lord, I was on the point on the 12th of January, where I made my points about the 12th of January letter. I think it's the 14th of January letter. My lords, you then move to the 18th of January, which is when Madam Justice Quindon Williams made her order, which is at page 54. And the relevant part is para 1, sub para 2. It is hereby ordered that, halfway down the page, the order granted on 15th December, wherein the respondent and so forth is restrained from taking any steps to remove the applicants from the jurisdiction be continued. My lords, that can only be on a proper construction. That on a proper construction is not precluding detention, any more than Mr. Justice Rahim's order precluded detention. That's one reason why. Another reason why is, by this point, the deportation order had been made. And if the intention of this order was effectively to prevent deportation, the very making of a deportation order, then the deportation order would have been set aside. But there's no suggestion that that was the intention. And so we say, on any footing, this order is not inconsistent with the, or doesn't in any way affect either A, the deportation order that had been made on the 12th, 14th, or nor does it prevent the making of a deportation order against the second appellant, if that is, against the first appellant, the son, if that is necessary. It says nothing about that. It is simply preventing removing. My lord, the other point to note about this order is a timetable is set for a trial which is to take place after service of evidence and evidential objections on the 12th of April, 2021. That's paragraph 8. Sorry. Yes, and my lord, you'll see para 7, submissions on the 31st of March. With decision on the 12th, yes. My lords, the next thing that happens is on the 28th of February, sorry, 28th of January, at page 12, you'll see the application, I think it starts actually at page 11, the application for the issue of a writ of habeas corpus. My lord, just one point to note. There is no suggestion that any distinction should be drawn between the mother and the son. It's essentially all the same. Paragraph 8, the applicants, one of which is a minor, remain incarcerated. But it's not suggested that a distinction should be drawn between them. And likewise, page 16, the affidavit in support of Maru Yuris del Tagotiga, who I think is a refugee in Trinidad, but he's there lawfully, and the uncle, as I understand it, of the son, and stepbrother of the sister, of the mother, makes this affidavit in support. That's paragraph 5, if you want to see who he is, page 16. Oh, it's a she. I'm told it's a lady. Forgive me, my lords. But again, there's no suggestion in this affidavit, see paragraph 11, for instance, that there is a distinction between the two. On the 29th of January 2021, page 61, you'll see Mrs. Justice Mohammed orders the permission to grant the permission to issue the writ of habeas corpus. She does so without a hearing. That's page 61. In both cases, and page 63. So there are two. There are two permissions, writs in both cases. And then at page 67, you have the return by the Chief Immigration Officer, or but on behalf of the Chief Immigration Officer, at page 67, and then from page 67 to 69, he sets out the return. And I draw attention in particular to paragraph 2. First named applicant is the minor daughter and remains in the her care at heliport. No other justification is given in relation to the son. And you'll see, essentially, he says breaches of the various regulations and also trying to enter while the country's borders were closed because of the COVID crisis.
Just one moment, Mr. Knox. I think we may have a problem with the connection to Lord Stevens again.
Yes.
Yeah. We're going to have to adjourn again to get the technicians to sort it out, I'm afraid.
Okay, my lords.
Last time, in fact, the problem turned out to be at Lord Stevens' end, and I'm afraid that if it is, we just have to wait for the problem to resolve itself.
Yes, my lord.
Yes, I think we're ready to resume.
My lords, I'm grateful. My lords, just on the return at page 67, just to emphasise, this return is plainly directed to both applicants' detention. You see that first from the distinction it draws between first and second applicant in the first 3 paragraphs, and thereafter, repeatedly, it talks about the applicants, or the second applicant or first applicant, throughout the rest of the paragraphs. Yep. So it's justifying or purporting to justify both detentions. My lord, on the same day, and this is not in the chronology, on the same day as the return, the appellant provides a speaking note for the anticipated hearing. And that you find at page 561. Or 560. And the only point I want to take you to for the moment is that this note does take the point at page 570 that there is a specific point for the son. That is to say, his detention is not lawful because there is no deportation order against him. So at this point, the point is taken. Yep. And that's essentially halfway down page 570. My lord, this appears to be the 1st of February. And then, on the 15th of February, if you go to page 573, you can see the submissions of the respondent. They begin at 572, and they continue to 591. And at least according to the dates on these documents, this is 15th of February, so made two weeks later. This document doesn't specifically deal with the point that there was no order against the son. So we don't deal with the point that's been made by the appellants at this point. The hearing then takes place on the 15th of February. And on that day, on the same day, Mrs. Justice Mohammed dismisses the notice of application, and you can see that at page 72. The order is made on page 72 is the order, and her reasons are given at pages 74 to 77. And they're fairly brief. As you can see at page 75, she simply summarises the effect of the return to the writ, and she then goes on to deal with the point at page 76, paragraph 5. She says, I refuse to order the release as I was satisfied that the return of the writ demonstrated the respondent had set out a lawful basis for the applicant's detention, as there is a valid deportation order, and so on. So she doesn't deal with the point that was made, at least in the appellant's speaking note of the 1st of February, that a distinction was to be drawn between the two.
She does say that restraining the deportation of the applicants pending the determination of the substantive constitutional proceedings and so forth.
My Lords, sorry, yes.
That is a comment about the deportation order, so it appears to be directed to both.
Yes. Well, she seems to be treating it as directed towards both.
Yes.
Now, my Lords, I should say this judgment is delivered on said to be delivered on the 18th of February at page 74, although the order at 72 is dated the 15th of February. My Lords, I'm told that according to the SFI, the hearing took place on the 1st of February, which seems a bit odd if the respondent's submissions were made on the 15th. But in any event, my Lord, whatever precisely happened, our position is that at the oral hearing, we do not understand it to have been argued that a distinction was to be drawn between the two. Now, Mr. Fayed Hussein, who has been representing the respondent in these proceedings, wasn't present at that hearing, and we haven't been able to find out whether or not the distinction was drawn to Mrs. Justice Mohammed's attention in oral argument. So I'm afraid I can't help any further on that. But what we do know is she doesn't deal with the point. And perhaps more importantly, for my purposes, the notice of appeal, which is at page 79, does not complain about that. Begins at 78, fairly short notice of appeal, 78 to 80. It doesn't say you failed to deal with the position of the son. It puts the appellants together in the same boat. Now, my Lords, if I can go back to the chronology, because between the 15th of February 2021 and the hearing on the 1st of April in the Court of Appeal, various things take place in the constitutional motion, which I should draw your attention to. That's at page 471, I think. Or you can pick it up, rather, at 472. And you can see that between the 24th of February and the 8th of March, and indeed in March, there is, first of all, the question of whether the judge should recuse herself is raised by the state because she is the wife of a witness the state proposes to call. That's our supplemental note. And there's also questions about the written objections. But the position, therefore, as at the 1st of April 2021, which is when the hearing in the Court of Appeal takes place, is that the timetable, which Mrs. Justice Quinlan Williams had anticipated, has gone slightly out. We know that much on the 1st of April, but it's not particularly out. And so on the 1st of April 2021, you have the hearing that takes place. And one asks, well, what submissions were made at the hearing by the appellants? And for that, one goes to page 507. And I'm told this by Mr. Hussein, these submissions, which you see in writing here, are essentially the submissions made orally at the hearing. These submissions are dated the 19th of March, 2021, So that's 2 weeks before the hearing. And the first point, there are a number of points which are raised, which I'm not inviting you to read now, but first of all, no distinction is drawn between the first and second appellant's positions. And so if you pick up, for instance, page 513, you'll see halfway down the page, the finding of the learned judge that forms the basis for this appeal is to be found at paragraph 5, and it sets out her finding. And then it continues for some time over to page 514, 515, 516. But essentially, no point is taken throughout this submission at all that no deportation order had been made against the son. Totally different points are taken. A number of different points are taken. And my lord, the other point to note, is the Hardiel Singh point. There is no point taken at this stage, and we say not very surprisingly, because not much time had gone by yet. No point is taken that it is now too long that the appellants have been in custody or in detention, nor is the point taken that it will become too long by the time the constitutional motion is decided. And one can pick it up most easily by at page 519. The argument that was being run is in the paragraph that begins, the ratio of tan t lamb. That's the point. If I can just ask you to read that paragraph beginning, the ratio of tan t lamb. So what's being said here is, it's essentially the point Mr. Ramdeen's been making this morning, namely Madam Justice Quinlan Williams' order on the 18th of January had, so to speak, rendered the deportation order ineffective, a nullity, and therefore there was nothing which could justify the detention. Because it couldn't be said that the detention was pending deportation. It was, on the contrary, it was pending the outcome of the constitutional motion at some distant point, an unknown point in the future. That was the argument that was being run. That was the only Hardiel Singh point being run. And that becomes more clear if one turns to page 525 in the second paragraph down, under the heading, can the power to detain pending deportation under section 16 be exercised where the deportation order cannot be effected. And you'll see here that what's being said is not a complaint about time itself, but the deportation order cannot be effected because you've got Madam Justice Quinlan's William order in the way, so to speak. That's what's being said here in the second and third paras on page 525. In particular, the paragraph in the current case is entirely focused on the first consideration herein above mentioned. The deportation order cannot be executed due to the existence of the order dated 18th of January. This is far from the first time the court's been called on to address and so forth. And then subsequently, and my lords again, page 529, halfway down, the three aforementioned cases. So this is after a description of the three cases saying that you could only detain for the purpose of deportation. The paragraph begins, the three aforementioned cases all demonstrate different situations where detention in circumstances where the deportation of the applicant cannot be effected has been found to be unlawful. So the argument being run was simply impossibility rather than too much time. And then the final paragraph on 529. Yeah. Well, and my lord, that's made good by the last sentence of that paragraph. Though the initial detention of the appellants may have been lawful, the authority to continue to detain would have expired upon the issuance of the order of the 18th of January. That's the argument being run. And then The next paragraph, the court below was not called upon to determine whether the appellants had been detained for an unreasonable time pending deportation. The question that the court ought to have answered lies one step before. Are the applicants being detained pending deportation? That can only be answered in the negative, and so forth. So that was the case, that was the argument in writing put before the Court of Appeal, and as we understand it from Mr. Hussain, that was the argument that was made orally to the Court of Appeal. So the too much time has passed argument simply wasn't run before them. Now, my lords, after the 1st of April, I should have said this if I hadn't, the hearing took place on the 1st of April. If one goes back to the chronology, you can see page 4, it's 487, 472, you can see various things take place in the constitutional motion after the 1st of April. And you can see there's quite a bit of, well, there seems to be some manoeuvring in relation to evidential objections and so forth. And a question arises as to recusal and so forth.
Yes, as I understand it, the evidential objections, the judge has decided to deal with that before the issue. She's decided whether or not to admit her husband's affidavit before deciding whether it's appropriate to recuse herself.
Well, I suppose, my lord, we imagine the thinking was, I'll decide whether I should even look at this affidavit. Yeah. And then if I do think the affidavit's admissible, then I will consider recusal. Yeah. So that's why she's done it that way round.
And none of these things have yet been decided.
None of these things have been decided, but none of this is drawn to the Court of Appeal's attention in the habeas corpus proceedings. No one writes to the Court of Appeal saying, by the way, you ought to know A, B, and C is going on in the constitutional motion. So it's not very surprising that the Court of Appeal comes to the judgment they do on the 21st of July. And we say, even if they'd been informed of it, there's no particular reason why the Court of Appeal would have been particularly concerned by the delay in the proposed timetable. And, my lords, we know one can infer that because when you get to the Court of Appeal's judgment, they actually anticipate that the constitutional motion will be heard by the end of the year. Which you get at, I think I'm right in saying, page 110, paragraph 84. And they're relaxed with that, and we say that was a perfectly sensible judgment, given the arguments that have been put before them. There was, and we say that sort of length of time in the context of proceedings in Trinidad and Tobago is perfectly reasonable. And COVID, of course, and all the difficulties. So that's how things stood.
You know, here we are now in March, and, well, we haven't got a ruling yet on either the evidential objections or the application for recusal.
No,
we're some way off yet from actually having a hearing and then having a decision, I suppose.
Well, the gap between evidential objections and the hearing, as originally posited, was about 2 to 3 months in the original timetable. Yeah. But I am bound to accept quite a lot of, I mean, this is why one of the difficulties your lordships, if I may respectfully say, are in, is that it's easy for me to uphold, but I say is the correct approach of the Court of Appeal. They've done nothing wrong, bearing in mind the lapse of time by the 21st of July. The problem in this case arises because of the lapse of time subsequently.
Yeah.
And how should your lordships approach that? But, my lords, if I can just go to the Court of Appeal's judgment briefly, because just to show you what I say, why they were plainly entitled to come to their decision. One can pick it up, I think, at page 82. Page 82 is the order. 83 is the judgment. And my lords, you'll see how they express the issues. Paragraph 5. paragraph 5, they say there are just two issues. One is, could he detain? The other is, has the continued detention become unlawful? And that's the issue which I say, in fact, was one which they, in reality, they took on themselves. Paragraph 80, page 88, paragraph 9, in summarising the background, they do advert to the position of the son. They're not ignorant of the fact that the son is, that there's been no deportation order against the son. They just say he is continued, he's still in the care of the mother. And then page 91, I think, sorry, page 90, paragraphs 19 and 20, you can see the appellant's submissions. Which mirror the issues which they said existed. And they deal with the first point at page 92, paragraphs 26 to 31. And their conclusion in particular is at 31, where they agree with the judge that section 16 provided a lawful ground for the detention, for her detention and the minor in her care.
Sorry, could you just give me those paragraph numbers?
Yes, of course. It's 26 to 31, where they deal with, quote, the lawfulness of the detention, what you might call the Quinlan-Williams order point.
Yes, thank you.
They deal with that and they reject it, and they say the judge at first instance, Madam Justice Mohammed, got it right. And in particular, that's at para 31.
I thought that you said that there were no oral submissions to the Court of Appeal about the time being reasonable or unreasonable.
My lords, I don't think there were. No, my lord, sorry, if I wasn't clear on that, no. Our understanding is there were oral submissions on the question of whether the order was lawful or could lawfully be carried out, because there was no pending deportation. Detention was not pending deportation. That was the argument. The detention is not pending deportation. But there was no separate argument in the Court of Appeal to the effect that too much time had now gone by, or that there would be too much time by the time the constitutional motion was finished.
The Court of Appeal were incorrectly recording Mr. Ramdeen's arguments then at paragraph 20 and the respondent's arguments at paragraph 22.
This is, my lord, yes, the paragraph 22 is the respondent's point, but the main point, as we understand in paragraph 20, is as we understand it, this is reflecting the way the argument was put in the written submissions. But it may not matter very much in the end, because the Court of Appeal does deal with the basic point about the passage of time. Whether of their own motion or because it was raised by Mr. Ramdeen, we say it's plainly dealt with by the Court of Appeal in any event. But in any event, my lords, we say, as far as I've taken to the Court of Appeal's disposal of the first point, paras 26 to 31, and then one goes to page 107, where they turn their minds at paragraph 73 to the reason for the delay, paragraph 73. And they say the court of, the appellants have invoked the court process. And they say at the end of 73, the appellants are therefore subjected to self-induced restraint. Now, my lords, if they'd stopped there, I accept that would have been an error. But they then go on in paragraph 74 to say, well, that's not the end of the matter, because the appellants are exercising their rights under the Constitution. And then they go on to consider 75. Accordingly, I proceed to consider whether their detention can be regarded as unreasonably long. Now, I suppose silently, by 21st July 2021. And she then goes on to consider the relevant principles. Paragraph 76, he says unreasonableness is not a matter of Wednesbury principles. Again, in my submission, correct. Para 77, it can't be said at this time, as in Tanti Lam, that deportation will not be possible. This will be so only if the court sees the constitutional motion so rules. And then para 78, we'll just have to wait and see, essentially. Para 79, until that time, however, reasonableness must be measured by the court proceedings. The appellants have deliberately and willingly embarked on the motion. Unless it can be shown that the proceedings are unreasonably protracted, this court must facilitate the hearing and determination of the constitutional motion. As long as the motion is receiving the attention of the courts in Trinidad and Tobago, it seems that the detention is within the band of a period which is reasonable. And then they go on to say that there are additional circumstances. We're not going to, in paragraph 8, we're not going to presume how the court will decide the constitutional motion, but it may be dismissed. In this event, the most important part of the judgment, we say, in this event, the appellants must be available to be deported. Their release may, however, result in their absconding with the consequent frustration of the valid deportation order. The court cannot shut its eyes to the real possibility that the appellants will abscond. Their illegal return following their initial escort out of Trinidad, coming back on the 24th, speaks eloquently of their desire to remain in Trinidad. They did so in breach of the laws of this and their own country. This is a real and relevant factor. And my lords, we say that's an unchallenged finding of fact, or conclusion of fact, rather, by the Court of Appeal. Risk of absconsion is obviously terribly important. And there's nothing wrong in any part of this in this part of the Court of Appeal's judgment at all, given what they were dealing with at the time. That's what we say.
Isn't paragraph 79 an automatic disqualification of the time taken up by the constitutional proceedings?
Well, my lords, I submit not. They're not automatically excluding the constitutional proceedings. What they are saying is, as long as the constitutional motion is receiving the attention of the courts, it seems that the detention is within the band of a period which is reasonable. My lords, I take your lordship's point. You might say they're saying, well, it doesn't matter very much. But on the other hand, one does have to read that in the light of the conclusion, which is at 84.
In 82, they say clearly it's not possible to forecast the final orders that will be made in the constitutional proceedings.
Yes.
That suggests that they're not hopeless.
My lords, I accept that. They are plainly not saying that the constitutional motion is hopeless. I agree with that.
If it's not hopeless, then should they be so dismissive of the period of time occupied by them?
Well, my lords, in the light of paragraph 84, they're not, in my respectful submission, they're not entirely dismissive. Paragraph 84, they say, we're confident that the hearing can take place by the end of the year. My lords, if they'd said, doesn't matter when the proceedings, it doesn't matter when the hearing takes place, I agree that would be an error. But you have to read the judgment as a whole. And as a whole, what they're saying is, well, the constitutional proceedings have slowed things down, but I'm confident they'll be heard by the end of the year.
But that assumption has been proved to be incorrect.
Yes, but I agree. My lords, well, my lords, I'm simply for the moment trying to explain why the Court of Appeal did what they did, because it is an important jurisdictional point, your lordships, where you've got the Court of Appeal on the face of it has done nothing wrong, and it's got it right. You may say round the edges that it could have been put better and things like that. But if the Court of Appeal's judgment is basically correct, what business is it of yours to say we're going to overturn it? As opposed to there are new circumstances which have come along, which makes it appropriate for the new circumstances to be investigated either on a remission or by making an application to the Children's Authority and so on and so forth. But that, I submit, it is a serious point. And my lords, the reason the state is so concerned is these are test cases. These aren't just sort of one or two odd cases. There are a lot of these cases going on at the moment. So
I had a degree of concern about the logic in paragraphs 80 and 81, insofar as they've made a finding that the applicant might abscond. And that was based upon, as far as I can see it, the fact that they were illegal immigrants and they'd come for a second occasion as illegal immigrants. And so every person who comes as an illegal immigrant on 2 occasions is likely to abscond within the jurisdiction, regardless as to their personal circumstances, regardless as to whether they have an uncle in the jurisdiction, regardless as to what security they can put up. So I just had difficulty in understanding what evidence they based those conclusions upon, apart from a presumption that was wide-ranging and perhaps not appropriate.
Well, my lords, I'm not sure at the moment to what extent the evidence in the constitutional motion was before the Court of Appeal on this appeal in the habeas corpus application. But there's quite a lot of evidence, but it's not specifically directed, I think I'm bound to accept, it's not specifically directed to the appellants. It's more generally about the problems that are faced in Trinidad and Tobago by illegal immigrants coming in and then absconding.
But you have to consider the specific circumstances of the individual. You can't generalize. Isn't that correct?
Well, I would agree with that as a general point. However, here in my submission, one is entitled to say you've come in once illegally, you've come back again. These are local judges who know the local circumstances well, and in my submission, they are entitled to take into account the fact, and there is a mass of evidence of this, of the great difficulties which are being caused by the amount of attempted illegal immigrants coming into Trinidad since 2020 and 2021, and the problems that they have caused. So, my lord, I don't understand there to be any appeal as such against this particular finding by the appellants at the moment. And we say it's not outside the bounds of a reasonable finding.
I just wondered also what the other circumstances that were taken into account. The conditions of detention, the ability of a child to have the company of people of the same age, the ability to have education and so on. I have no idea as to whether those circumstances were weighed in the balance in coming to a conclusion that the period was reasonable.
Well, my lords, I understand the point, obviously, that's been put to me. All I can say in answer is the great, I'm afraid it's an old gramophone record, these points simply weren't raised. In one sense, I accept you might say these points should have been raised with the Court of Appeal. The fact is they weren't. Is it right, therefore, to say the Court of Appeal got it wrong when, on the face of it, they have dealt with the arguments put before them by the parties in the way they wanted to? And it's not a great answer, my lord, but I submit it's a sufficient answer. And one must bear, as I've said before, one must bear in mind the great difficulties the state is in dealing with this problem of large numbers coming in from Venezuela, of illegal immigrants. And my lords, it's worth noting, this is in breach of the COVID rules, in breach of, there's no visa. Why should, it's not just a matter of no evidence. There's no visa, there's no passport. Can't even tell who they are, really. Oh, my lord, yes, and of course, in the country at that time, Trinidad was in total lockdown. So I submit one is entitled to draw some... this is not an unfair inference when you add everything together to draw. And in my submission, it wouldn't be right for the board to say, we're going to interfere with that finding. Oh. I should, Mr. Hussein adds all the court hearings are virtual and obviously were virtual at that time. So, my lords, I say the Court of Appeal got it right. I accept, my lords, you may say arguments weren't raised, which maybe they could have been and so on and so forth. But on the material they had, you cannot say they have come to an unreasonable conclusion which the board should interfere with. My Lords, in our written case, we referred to the case of Bell, which is the Privy Council's decision back in the 1980s about delay in the context of criminal proceedings in Jamaica, where the court emphasises, and I'll just give you the reference at page 627, the Privy Council did emphasise, I think it's in a speech or opinion of Lord Templeman, they emphasised the importance of paying attention to the local court's assessment of questions of time and reasonableness of delay. In fact, in particular, the Court of Appeal talks about the Court of Appeal's assessment. So for that reason, too, we say there's no basis for interfering with the Court of Appeal's assessment. My Lords, can I also just mention this point? When one looks at the cases, the principle in relation to delay is set out in Lord Dyson's judgment in Lumber, page 710. How should you deal with the question of delay in this type of case? And it's not just a matter of computing the time. It's a matter of taking into account all the circumstances, including risk of absconsion and things like that. But it's page 710. Perhaps I can just take you to that, if I may. Paragraph 103, I think. Paragraph 103 and 104. And I suppose 105.
In relation to paragraph 103.
103 to 105.
In relation to 103, when do you say that there is a realistic prospect that deportation will take place?
Yes, but my Lords, one looks at all the circumstances.
No, but the first question in paragraph 103, the convenient starting point is to determine whether, and if so when, there is a realistic prospect that deportation will take place.
Yes.
I'm just wondering, what do you say is the reasonable prospect there?
Well, my Lords,
realistic prospect.
My Lords, as things stood before the Court of Appeal, I said there was a reasonable, realistic prospect.
And
as things stand, sorry?
As it stands today.
Well, my Lords, I say there is still a realistic prospect that it could take place. There doesn't seem to be any particular reason why. You may say I'm being optimistic, but my Lords, I say there's no particular reason why actually the constitutional proceedings couldn't take place within a few months. And when you look at the lengths of time in some of the cases, it's not unusual for there to be up to 26 months, even in England, when people go through the appellate processes and things. Now, but you may say, well, that's an awfully long time. My Lords, I accept it does seem a fairly long time, but it's not so long as to mean that a person in detention must be released notwithstanding the risk of absconsion or absconding. And that's really what this case is all about. If there is a risk of someone absconding, at what point do you say, well, I'm just going to let you out anyway under a supervision order? And that, we say, is almost impossible for the board to decide. And that is why we say, really, you'd need proper evidence on all this, which should no doubt be put before the local courts.
But because the issue wasn't raised before the Court of Appeal, the question of what conditions they could be released from wasn't.
It's not. I should have made that point. There's nothing in the argument saying a supervision order would be much better because, and that's important because supervision orders aren't necessarily easy to police. So all those sorts of what you might call all the alternatives to detention haven't been looked at below at all. My Lord, that may be, of course, simply to the very narrow nature of these proceedings. Was the detention order itself unlawful? And then you get the passage of time. But again, no one's been raising this point to the effect that we should now be considering a supervision order.
Just on the subject of the scope of these proceedings, I'm sorry to dart about, but the point's been sort of bothering me at the back of my mind all day. The Torres point I mean, this is a habeas corpus application, and the purpose, as I understand it, of such an application is to find out what lawful authority there is for the detention of the applicant. And here, the authority is effectively Section 16 of the Act, taken together with the deportation order, which is the precondition of Section 16's application.
Yes.
Now, if it's intended to challenge the lawfulness of the deportation order on the Torres basis, I rather wonder whether that's an issue that can be determined in the habeas corpus proceedings, or if it doesn't have to be subject of an application for judicial review.
My Lords, I think it's fair to say at first instance, I don't want to go into all the arguments, but one of the points raised by the respondent was precisely that the proper way of challenging the deportation order, if that was what was going on, was not by way of habeas corpus proceedings.
Yeah.
That all the court should really do at the habeas corpus proceedings is look at whether there is a lawful authority,
Yeah.
i.e. the deportation order. I suppose you might say, of course, there's no lawful authority if a condition precedent to the exercise of the power has not been satisfied.
Yes.
And that, I think, was largely what Mr. Ramdeen's argument seemed to be driving at. The conditions precedent haven't been satisfied. Ergo, there's no good answer to the writ of habeas corpus. But the rather different argument about the length of time which had passed is, in my submission, well, I have looked at the cases. I think I'm right in saying Hardiel Singh was a combined judicial review and habeas corpus application.
Yes.
Lumba, I think, is just a judicial review application.
Yes.
Yes. And, my Lords, in the Court of Appeal, I think I'm right in saying, paragraph 23, they sort of record Mr. Hussein's submissions. He's just showing them to me now. And he says, well, we don't need to look at that aspect of the case because we're dismissing the appeal anyway, broadly.
Oh, I see. Yes. Yes, because what's going through my mind is of course, the deportation order is lawful so long as it stands,
Yeah.
unless and until somebody sets it aside. And habeas corpus isn't a quashing procedure.
My Lords, no. Well, my Lords, this was a point which we did try to make in the Court of Appeal below, I think, and that you will get from paragraph 23. We said this is really for judicial review, not for habeas corpus proceedings. Yeah. But we are where we are, and there is the position that the appellants are in detention.
Yes, I can see that a court applying its common sense might decide to perhaps treat the application as one for judicial. I mean, it's a prerogative writ, habeas corpus, or I mean, there are various ways it could be flexible in accommodating the.
You could give directions to treat the hearing as a judicial review hearing as well. I mean, all sorts of procedural mechanisms.
Yeah, yeah. Yes, thank you.
Well, my Lord, Mr. Hussein does make the fair point. Hence, in these proceedings, there's not much evidence. You've just got the written. So, again, one has to look at, that's why I keep on that same point, look at the position in these proceedings as before the Court of Appeal, given the nature of the hearing. My Lords, I just wanted to make good. I've referred to Lumba. Well, I think I'm right in saying that in the paragraph I drew attention to, Lord Dyson does say that obviously a relevant question is, in deciding reasonableness, is you have to take into account the question of the risk of absconding. Yeah. If there is a risk of absconding, the period can be lengthened. Notionally, I'm talking, so lengthened. It's not just a matter of totting up the months. And that's, I think, in the paragraphs I referred to, 103 to 105. And at 121, my Lords, in the same judgment, para 121, 714. I just feel I mentioned that for your note. I don't propose to read it out, but it's the same point. Mm-hmm. And my Lords, just by way of example, if one goes, for instance, to page 987. think I'm right in saying you've said 987.
Yes.
I may have given a bad reference. This is a United Kingdom case where it suggests that 26 months, paragraph 20, my lords, forgive me, I've given you a bad reference. Perhaps I can come back to that, but... Sorry?
There's a page missing, I think, in the...
Yes.
Oh, no, I beg your pardon. It's just as a quotation inserted.
I've got 987, 20. But if you type in 26. As far as Trinidadian cases are concerned, at 885, I'm just talking now numerically. Paragraph 12, I think, is a decision in the first instance. There's an appeal, I think, in the Contrera case.
Sorry,
page
paragraph?
130.
Thank you.
This is the Court of Appeal talking about the length of time for which the applicant had been detained. And you'll see she entered in November 2020 when the borders were closed. Content of constitutional proceedings hasn't been disclosed. In our view, it's not unreasonable for the immigration authorities to observe a virtual stay of deportation pending the outcome of related proceedings. And then they go on to say these are about 12 months. I think my lords, I'm not sure where I got the 12 months from, but my lords, can you take it from me for the moment that this was a case of 12-month detention? Yes, I apologize. And then, my lords, at page 927, there's another Trinidadian decision, paragraph 49. This is in the case of Gomez, where a very similar lineup. At page 917, it's one of the related cases, but they say at paragraph 49, they refer to a period of 7 months as not being unreasonable in all the circumstances. And my lords, the UK case I wanted to refer to is at page 967, beginning at 961, on the application of Abdullah High. The judgment, I think, of Lord Justice Moses, which is, I think I'm right in saying, referred to in Lumba with approval. And at paragraph 49, 29, you'll see what he says there about length of time these things can take. So we say that the length of time is not necessarily such even now, or will be such, as to require the release, or as to make the detention unlawful. My lords, but we emphasise in real life, we say it's difficult for you to decide that, and we've referred in our supplemental note to Lord Dyson's dictum, I think, in Lumba, where he says it's not appropriate for a third-tier tribunal to try to decide these things, although it might be for the Court of Appeal, but not for the third-tier tribunal. My lords, the only other thing I would like to draw your attention to briefly is this. If I can just go to the Immigration Act, and that's in we put the whole Immigration Act in the supplemental bundle because only certain parts of it were in the original bundle, and not all the most important parts. But it's in the supplemental bundle, which was filed, I think, early this morning. If I can just ask you to look at certain provisions in that. And it starts with section 3, which is, my lords, the Act begins at 45, supplemental bundle 45, but section 3, you can see the structure. And Section 3 is important because this is the only statute which, as I mentioned earlier, the only statute which tells you anything about how immigration is to be dealt with in Trinidad. And Section 3, except as permitted under this Act, no person may be admitted into Trinidad and Tobago as an immigrant, or being within Trinidad and Tobago remain there as an immigrant. So you've got an absolute prohibition on the face of it. You then have you then have Section 40, which is a few pages on, at 77, any person who comes into Trinidad at any place other than the port of entry and fails to report to an immigration officer for examination, and then it goes on to say, on the next page, 78, is liable on summary conviction. So that's one of the offences. And then, as far as the regulations are concerned, if I can just take you to the relevant ones, they begin at page 90, I think I'm right in saying? 90, yes, 90. They begin at page 90, supplemental bundle, and the relevant ones are 109, page 109, that is.
Sorry, it's a section?
13.1, Regulation 13.1 at page 109.
Thank you.
And these are the breaches which are alleged and not disputed. Subject to sub-regulation 2, every person seeking to enter Trinidad shall be in possession of a passport issued by the country to which he's a citizen, he or she's a citizen. And then 13.5, a little bit further down the page, if essentially you have to have a visa. Again, there was no visa here. And going back to the main Act, you can see at Section 8 a provision, and this is on page 55. It begins on page 54. 8.1. Except as provided in subsection 2, entry into Trinidad and Tobago of the persons described in this subsection, other than citizens, and subject to section 72 residents, is prohibited. So you've got an absolute prohibition on certain types of people coming in. And one of those, and this is in the evidence in the constitutional motion, one of those is, you will see is on page 56, there's P, persons who cannot and don't fulfill any of the conditions or requirements for lawfully coming in, and then Q, any person who from information or advice which in the opinion of the minister is reliable information is likely to be an undesirable inhabitant. So you have certain types of people who simply can't be admitted. Now, if one goes to page... My lords, page 350, at paragraph 31.
This is back in the main bundle.
Yeah, it's back to the main bundle, sorry. Now, the point is this, that an order or declaration has been made that illegal visitors, and it was made in July 2020, are undesirables for the purpose of the relevant 8.1Q, and that's at 31. And so you'll see that's in July 2020, after the closure of the borders in March 2020, which is in paragraph 25. So we say it's perfectly reasonable to make such an order. And the actual order itself is at page 1066 and 1067. It's a little bit difficult to divine, but if I can just briefly explain, that at 1067 there's a letter to the Minister of National Security from the Chief Immigration Officer, essentially asking him to declare certain types of people as undesirables. That's 1067. And then you'll see on 1067 a handwritten note, agreed and approved S. Young. So the Minister has approved the declaration that people who are illegal immigrants are to be treated as undesirables for the relevant purpose. And also, if you look at 1066, you can see on the minute sheet, the permanent secretary, there's a little box at the foot of the page, which basically says the submission at minute 7 is approved. So it has been decided in Trinidad and Tobago to exclude, pursuant to statutory powers, certain types of people, and those are people who are coming in unlawfully. And we say this is, makes it very difficult in real life to see what legs the constitutional motion has. But even if I'm wrong on that, we say at the very least it does appear to face substantial hurdles. My Lord, one other point I should mention, and that is under the Immigration Act, the furthest things go in favour of immigrants is that they have a right of appeal to the minister against a deportation order, and the minister, in exercising his powers under that, can take into account humanitarian considerations. And for that, it's page 70 of the supplemental bundle. Which I think is the Act. Perhaps I should start at section 28, which provides for deportation orders. 28 provides for a deportation order. And then section 29 provides for execution of deportation and so forth. My Lords, I should say, although the state didn't rely on it, section 30 prevents the court reviewing any deportation order, but as that's a new point, I don't think I can take it any further. But, my Lords, in any event, this is the structure. You have section 28 deportation orders and the right of appeal against deportation orders.
Resources.
Okay. And then in the immigration regulations, which begin at 89, section 28 does give, they begin at 95, section 28 does give the minister a power to exercise humanitarian considerations. I think it's sections 28 and 29, regulations 28 and 29, on pages 118 and 119. And in particular, it's 28(1)(b). We say this really is the appropriate structure within which all of these considerations should be considered. And the constitutional motion, of course, you're entitled, I suppose, to say that the Immigration Act is inconsistent with the Constitution and so on. But on the face of it, the statute sets out how the challenge is to be made, and no such challenge has been made with certain limitations. Now, my Lords, I accept, however, that I can't at the moment, certainly before you now, develop the point that the constitutional motion is totally hopeless. We've set it out in writing, but we certainly say it is not, on the face of it, a very strong one. We do say that. And one point in particular we make is that in the interview which the mother had on the 15th of December, she didn't give us reasons for leaving Venezuela, that she was being persecuted or the subject of political persecution or anything like that. That came only later in evidence, I think, in reply in the constitutional motion, where she said that she had been subject to that. If I can just give you the reference for her interview. Her interview is at 1079, begins at 1079 and at 1082 to 1083. And then her affidavit in response, saying I have been subject to persecution and so forth, is at 437, paragraphs 2 to 3. My Lords, finally, I just wanted to show you the Children's Authority Act and how things work under that. My Lords, that is in the supplemental bundle at page 51. Children's Authority Act. And if I can just briefly...
I'm sorry, the page number?
Well, it begins at page 13, or perhaps no, the index begins at page 12 of the supplementary bundle.
Oh, yes, I've got it. Thank you very much.
And essentially what this Act does, it sets up, quote, a children's authority, who is to look after the interests of children specifically. And all I need to do is just take you to one or two sections in it so you can see the basic idea, which explains how it's to operate. Page 17 sets out the objects of the Act. To promote the well-being of all children in Trinidad and Tobago, provide care and protection for vulnerable children, and comply with certain obligations under the United Nations Convention on the Rights of the Child. I accept that there may be arguments as to how one interprets that, but obviously it is arguable on the face of it that this will cover the child coming in as an immigrant. And then Section 4 establishes the Children's Authority, and then Section 6 sets out the duties of the authority, page 19, essentially to promote the well-being of the child and so on and so forth. And then subsection 6, subsection 2, sets out the considerations to be taken into account by the authority. And obviously one of the questions is the relationship with the parents and the family, and all sorts of things are set out in 2. Going over to page 24, section 14.1 requires the authority to maintain assessment and support centres, so forth. And then sections 22 and 23 set out what the authority is to do when it's of the view that a child is in need of care and protection. And it defines in 1A the circumstances in which a child is in need of care and protection. And, my Lord, I draw attention to one thing in particular, 1A subpara C, a child whose parent or guardian is prevented by reason of mental or bodily disease, infirmity, or any other circumstances. So on the face of it, that might cover the mother in this case. From providing for his upbringing, there is no available person or persons capable, fit and willing to undertake. So that, my Lord, would seem to be the section under which an application could be made on his behalf.
What section again, please?
Forgive me, my Lord. 22, 1A.
Thank you.
Subpara C. My Lords, you might ask, how do you ever get the thing in front of the Children's Act authority? And the answer to that is in subsection 2. A police officer or any other person having reasonable grounds for believing a child's in care of need may seek the assistance of the authority. So that appears to be the structure. And then section 23 provides for what the court can do.
Can you help me, Mr. Knox, in relation to the UN Convention on the Rights of the Child and its status in Trinidad and Tobago?
Non-incorporated. Not incorporated, save, of course, my Lord, to the extent you see it referred to in 3A.
That's what Lady Hale said in Nadica.
Yes.
Paragraph 72, to which we were referred.
Yes.
But I understood it to be submitted against you that it is incorporated.
Well, no, my Lord, forgive me for saying it like that, but our understanding is there's no statute which incorporates it. All that has happened is it is recognised, obviously, in this Act here, and only to that extent it has application by reference to this Act. But there is no separate Act under which it is incorporated into the law, into the domestic law.
Thank you very much.
So, my Lord, what we say is broadly, well, there is provision here under which the son could perhaps apply to the Children's Authority, but that shouldn't affect the question of whether the detention was unlawful or indeed is still unlawful. That's a matter for a different application. My Lords, can I just give you the references to our concern, or the concern of the state about handing over children, and it's pages...
if I could, just before you move on to that,
yes.
What are the provisions of the United Nations Conventions on the Rights of the Child that are incorporated in this Act? Because there's a limited number of them, isn't it? Under 3A.
My Lord, forgive me.
All of it. For instance, Article 9 of the Convention would require the state, as a direction to the state, not to separate families unless it's absolutely necessary. And I'm uncertain whether that article is also to be applied.
My Lord, forgive me, I found it quite difficult to hear a lot of what your Lordship said.
Section 3A
Yes.
Only incorporates certain of the rights, the UNCRC
Yes.
rights, certain obligations. Wondering where I find these certain obligations.
My Lord, as I understand it, they are not identified as such. You have to work it out from the Act itself. That's where you have to have a sort of Venn diagram to see quite which have been and which haven't been.
Thank you.
Yes, and it's not a situation where the Act is said to incorporate obligations under the Convention, but rather the objects of the Act are said to be to comply with certain obligations.
Yes.
So it's meant to prevent, it's meant to, I suppose that's really a guide to how you interpret and apply the Act.
Yes.
You know, if you're giving it a purposive interpretation, we're told here what A, B, and C, what three purposes of this Act are.
Yes. But if, for instance, there was something in the Convention which was totally outside the Act, ambit of the Act, then on the face of it, the Act, that is not either expressly or implied incorporated. It's an irrelevant obligation for the purpose of the Act. My Lords, can I just mention there is a summary of the difficulties faced in Trinidad and Tobago. I'm afraid I've lost the reference for the moment, but can I just deal with the question of trafficking? There is evidence about the problems of trafficking, and therefore, as that affects children and minors, the references are page 409, paragraph 13, page 425, paragraph 28, and 430, paragraphs 39 to 40. I'm just giving you the references briefly. My Lords, the other thing we say, even in the appellant's own case, they urge, at page 487, paragraph 20, that the mother and the son should be kept together. And this is one of the difficulties this case raises. And my Lords, finally, we say that was never alleged that the conditions in which the appellants have been kept were bad or unreasonable, save on the application for permission to appeal to this board, to which the state put in an answer, pages 203, or paragraph 203, paragraph 20, page 203, paragraph 20, where the state said no, perfectly adequate. And then there's a letter which exhibits all sorts of photographs and details and things at pages 209 to 218. And my Lords, on the face of it, when you look at those photographs, I suppose we can all take photographs that look flattering and all the rest of it, but even so, this is not a case where it is seriously alleged, and there's any evidence before you, of very unpleasant conditions in the heliport. My Lords, there was one reference which I have now lost, but in one of the cases it sets out, it gives a summary of the evidence in the constitutional motion about the difficulties facing Trinidad and Tobago. If perhaps I could just find that, I don't propose to waste your time now, but I had it and I seem to have lost it. But it's it's just 3 or 4 pages in a judgment, I think, of the first instance of a Court of Appeal judge in Trinidad, which heard all the same, or had before it all the same evidence. And it sets it out in not great detail, but it summarizes it, which I submit is a rather useful background in deciding the reasonableness or otherwise of the length of detention that's so far taken place and the problems which face the state.
Yep.
But, my Lord, subject to that, and I shall provide the reference as soon as possible, perhaps by the end, if I can just get up at the very end, those are my submissions.
Thank you very much, Mr. Knox. Mr. Richards.
My Lord, if I may, I intend to address briefly 5 points in reply.
Yes. Now, you don't have much time because obviously your leader took up a great deal of the time available, but you did lose about 10 minutes because of breaks, so you use that time.
I'm very grateful, my Lord. The first point is the suggestion by my learned friends that the appellant's arguments on this appeal are new ones. And to that, there are three answers. First, it's a mischaracterization of the position. My learned friend has conceded that the key point on the absence of a deportation order in respect of the child Jesus was taken before the High Court. But can I show you too the submissions before the Court of Appeal and parts of those submissions that Mr. Knox did not show you. At page 529, my Lords will see at the top of that page an extract. It begins at page 528. An extract from the judgment in Troy Thomas, which is one of the leading local cases on the Hardy-Singh principles. And the points of particular importance are emphasised in bold. So at the top of page 529, point 5, the power of detention that is conferred to enable the machinery of deportation to be carried out is impliedly limited to a period which is reasonably necessary for that purpose. So the reasonable period point was taken, and as my Lord Stevens has observed, the Court of Appeal recorded that at paragraph 20. Point 14 of Troy Thomas is also emphasised in bold. Special considerations must apply in the cases of minors, families, or vulnerable groups. So the need to pay specific regard to the circumstances of minors was emphasised. And then at page 530 of the submissions, reliance was placed on the judgment of Madam Justice Kangaloo in the case of Sedeno. Your Lordships will have seen at paragraph 82 of Justice of Appeal Dean Armourer's judgment in the Court of Appeal that the court considered Madam Justice Kangaloo's decision in Sedeno to be very compelling and to have given them much food for thought. But you haven't seen the judgment itself. May I ask you to turn it up at page 917 of the bundle? You'll see at paragraph 3 on page 918 that this was another case of a minor child and their mother. You see at page 925, paragraph 39, Mr. Ramdeen's submission that there was a specific challenge to the lawfulness of the child's detention because it was based on an unwritten policy of the Immigration Division that a child cannot be separated from the parent, and that could not possibly justify detention. And then at paragraph 65 on page 930, the learned judge's conclusion that detention couldn't be justified, and in that regard, the second sentence, the court notes that the first applicant is a minor who is being detained pursuant to an unwritten policy about which none of the respondent's opponents has condescended to give even tangential evidence. So the fact that it was a policy only and not a deportation order in section 16 that will be relied on was taken in Sedeno, and Sedeno was drawn to the Court of Appeal's attention in this appeal and gave the court much food for thought. So my submission, my lords, is that the essential points we now take were taken below. Of course, your lordships already have the point from our written case that these issues were traversed more fully in the case of Navarro-Gobin that was heard at the same time. That's the first answer to the new arguments point. The second answer is that, as my learned friend accepts, the Court of Appeal made new findings which involved new errors. So it's unsurprising that those errors which had yet to be made weren't canvassed before it. In particular, the court concluded of its own motion, in my learned friend's words, that, and this is paragraph 79 on page 108 of the judgment, as long as the constitutional motion is receiving the attention of the courts of Trinidad and Tobago, it seems that the detention is within the band of a period which is reasonable. That conclusion, with respect, my lords, was plainly erroneous in light of the decision in Lumba rejecting any suggestion of an exclusionary rule. The third answer on the new arguments point is that even if our arguments were entirely new, permission has been granted and they've been fully argued before your lordships. The board's practice is that it may consider such arguments, and for your note, an example is the case of Arnie at page 831, letters G to H.
Sorry,
of the report.
reference again.
Arnie, my lord.
Page?
831,
Thank you.
letters G to H. That was the first point. The second is the position of Jesus the child. Mr. Knox says that Jesus was in the care of his mother. The true position, of course, is that he was detained. Mr. Knox says that the state asked us the questions in pre-action correspondence and left it to the mother to take action. She did take action, my lords. She brought habeas corpus proceedings, not only in her own right, but as her son's next friend. And the application was supported by an affidavit of the boy's aunt. That's page 16. Mr. Knox argues that the deportation order against the mother was in respect of the child for the purposes of section 16 of the Act. With great respect, my learned friend, that is obviously untenable as a submission on the face of the order and of the statute. I won't take you through all the statutory provisions, but could I ask your lordships in due course, please, to note the definitions in section 2 on page 48 of the supplementary bundle of deportation and deportation order, the relevant power to deport, to issue a deportation order in section 11, the power of detention in section 16 itself, and section 28 on page 70, which relates to the service of deportation orders. In my respectful submission, there was clearly never any basis for the detention of this child, and the courts below obviously erred in holding otherwise. As of last night, my lords, we do have a deportation order. But whatever the effect of that order may be, it cannot erase history. Jesus the child has been unlawfully detained for 14 months. And no further period of detention under section 16, in light of the new order, could possibly be reasonable in my submission. There is no prospect of the courts below saying otherwise in the event of a remittal. My lord, he should be released, and released now. Prolonging the boy's detention by remittal, and for how long would such remitted proceedings last, one has to ask, would be a grave injustice. The third point is my learned friend's submission that the constitutional motion is hopeless, or near hopeless. It's a submission inspired by Lumba, but my learned friend ignores what Lord Dyson said in Lumba at paragraph 120, that's page 714 of the bundle, to the effect that one way in which the court can readily assess whether a claim is hopeless or has some merit is by reference to decisions in the proceedings themselves. In particular, he referred to where there has been a grant of permission to appeal, and the court will easily recognise that the claim has some merit there. In the present case, the question whether these constitutional claims has any merit has been repeatedly considered by numerous different judges of the High Court in deciding whether to grant interim relief. All of the interim orders restraining steps being taken towards removal, steps being taken to remove the claimants in the constitutional proceedings were made on the basis that the claims raised a serious issue to be tried. And one can see that from the Court of Appeal's decision in Valeria Leon, page 1335. But of course, in this case itself, Justice Charles, Justice Rahim, and Justice Quinion Williams each made interim orders, which can only have been made on the basis that there was a serious issue to be tried in the claims. Fourthly, there is the question of absconding. We have submitted in our written case that it was for the state to prove any risk of absconding, and the authorities we've set out at paragraph 30.7. My learned friend says that the Court of Appeal made a finding of fact that there was a risk of absconding. With respect, that's not a proper characterization of what the Court of Appeal did. What the Court of Appeal did was, in the absence of any specific evidence, draw a generalized inference that because these people were seeking asylum and because they had entered prima facie illegally, they were liable to abscond. And that, as my Lord Stevens observed in argument, and as Lord Dyson held in Lumber, paragraph 123 on page 715, is an error.
Mr. Richards, you've now been speaking for 11 minutes. Are you in a position to wrap up?
Yes, my Lord. That takes me to the final point, which is the suggestion of remittal to the High Court, based on Lumber again. Lumber, I would only emphasise, was a claim for damages. Mr. Lumber was no longer detained by the time the appeal reached the Supreme Court. The appropriate course in this case, in my respectful submission, is that which the Court of Appeal took in the case of I and the Secretary of State. The references are page 789, page 797, and page 801, where it remitted a damages claim, which will have depended upon when exactly the reasonable period expired, to the High Court, but ordered immediate release. In my submission, my Lords, there is no end in sight to the constitutional proceedings. Jesus must be released, and if he must be released, the further detention of his mother cannot possibly be reasonable. My Lords, those are my submissions in reply.
Thank you. Very well. Yes, Mr. Knox.
The reference I wanted to give you.
Oh, yes.
It's, in fact, the page 918 to 923 in the same case as my learned friend just referred to.
918 to
918 to 923 summarises basically the same evidence as you have in this case on the constitutional matter.
Well, we're grateful to all counsel for their assistance. We'll now take time to consider your submissions, and we'll let you have our judgment as soon as we